Mr. Hernandez, a jury of your peers convicted you of one count of second-degree murder and one count of felony firearm. The jury rejected your claim of self-defense. During the trial, I recall the audio from your 911 call where you unequivocally told the 911 operator that you were going to kill this man. She did what so many of our 911 operators do on a daily basis, what they are trained to do. She tried to de-escalate a desperate situation. She deserves recognition for her effort. She did everything she could to prevent you from firing those shots. But as we heard during that call, your intent was clear. You were going to kill him. The shots that rang out shortly thereafter were shots fired in rapid succession. You could hear them on the call. One shot was close range, close enough the medical examiner testified to leave searing around the wound in the clothing of the victim. It was clear that nothing the 911 operator said to you was going to change your mind. You had the chance. You could have listened to her. At trial, you claimed you acted in self-defense, and I think more than anything, this case best illustrates our society's often superficial relationship with the law. Because legal concepts like self-defense are often spoken about, tossed around, as if everyone who hears the term somehow has a complete understanding of its meaning. Not its pop culture meaning, but its true meaning, its legal meaning. Its meaning rooted in the law, developed over the centuries in our jurisprudence. The legal concept of self-defense, the right to self-defense. Self-defense is a human right. It is not conferred upon us by law. It's one that flows from each one of us to the law, and which therefore has demanded codification and development within the law. Every human being, by nature, by his or her very existence, has the right to defend themselves. But as with every right, the right of self-defense carries a heavy and grave responsibility. It is to be used only among the most serious of circumstances. It is a decision made in the most trying and stressful of situations, and one that is often exercised in a matter of mere seconds. But it is a right of last resort. The law tells us under which circumstances the right of self-defense may be invoked. One must have honestly and reasonably believed that he or she was in danger of being killed or seriously injured. One may not kill or seriously injure another person just to protect himself or herself from what seems like a threat of only minor injury. And finally, at the time one acts, he or she must have honestly and reasonably believed that such action was immediately necessary. So honesty, reasonableness, and immediacy, those are the pillars of self-defense. And your actions in this case, even if it is assumed they were honest, were not reasonable, nor were they immediately necessary. The 911 call and the medical examiner's testimony confirm this. Mr. Mansfield did not have to die. He did not deserve to die. He posed no immediate threat to you. He died only because you decided to end a verbal argument with 6 bullets. That is not reasonable. That is not self-defense. That is murder. Accordingly, it is the sentence of this court that you shall be committed to the Michigan Department of Corrections to first serve 2 years on the charge of felony firearm. You will receive credit of 425 days for the time you have served. Consecutive to the felony firearm, you shall be committed to the Michigan Department of Corrections to serve a minimum of 240 months to a maximum of 432 months for second-degree murder. I note that the minimum sentence is at the top end of your sentencing guidelines established by the state legislature. Your guidelines are low because you have no prior criminal history. And again, I sit here and I ask myself, why did this have to happen? Your costs include $68 state costs, $130 crime victim rights, and $1,000 in court costs. This is the final sentence of the court. You will receive a form that will explain your appellate rights. Thank you.
All right.